Yeah, thank you very much for the possibility to present here. I think it's a great opportunity to engage in more dialogue between the different Ascola chapters. And we will have a German chapter actually quite soon, initiated by Thomas Weck. And of course, we hope to do lots of events for the German chapter in the future. This is not already an official event of the German chapter, but I'm happy to be the co-head next to Thomas Weck, who is actually the German founding father of the Ascola German chapter. And yeah, this is just an announcement on this occasion. But today I'm talking about the DMA, the Digital Markets Act in the European Union, and efficiency considerations in different aspects of DMA procedures. And I will present this topic. I want to present this topic to you in 9 steps. I will just start with a short introduction to the DMA and its enforcement to give a glimpse of the DMA to those of you who are maybe not so familiar with it. And then I will delve into different aspects of the DMA to look at what the meaning of efficiencies in DMA enforcement could be. So I will start with the legislative process. How were efficiencies discussed in it? I will look at indications in the DMA. What does the DMA itself tell us about the relevance of efficiencies? And then I will go to different stages of the DMA enforcement procedure. So I will walk you through the enforcement process of the DMA as it will be in the future, and look at each stage of the DMA enforcement to inquire whether efficiencies could be relevant to a certain extent in that regard. And we will actually go on then to compliance and regulatory cases, discretion of the Commission to intervene. Is there some kind of objective justification? What about the setting of fines? And finally, contestability and efficiencies. And though I've just learned about, or have learned about the Asian approach, that it's common just to listen for 90 minutes and have questions at the end. Personally, I'm very familiar with also you asking questions in between. If anything is unclear, I'm happy to take questions whenever you have them, and it could improve the understanding of the discussion. So first of all, to give you a short introduction on the DMA, what is the DMA about, and how does DMA enforcement work? I will not go too much into history, but I think you know a lot about the background of the DMA already. There has been this discussion about too lengthy enforcement of Article 102 TFEU, so the abuse of a dominant position proceedings against large digital gatekeepers in particular. Enforcement has been considered too lengthy and too ineffective, and that's why the DMA has been enacted. And the DMA is a mixture of actually competition law, case law that has been put into a special regulation to basically turn competition law, case law into per se rules, and new obligations for gatekeepers, which essentially are large digital platforms, for certain aspects like vertical or horizontal interoperability or certain access to data provisions. So it's a mixture of these two aspects. The DMA, so the proposal, of course, has been made by the European Commission to introduce the DMA, as is the normal legislative procedure in the European Union. And the goals of the DMA are distinct from the goals of competition law, namely it's ensuring contestable and fair markets in the digital sector, which has already been stipulated in the draft DMA. And the rationale behind it is to have quicker intervention than in standard competition law proceedings. So with per se rules, the undertakings, this is actually the intention, shall exactly know what they have to do, and the Commission shall exactly be able to determine when the undertakings comply and when they do not comply. And this is somewhat a deviation from the more economic approach that in case of abuse of dominant proceedings said we have to look at the particulars of the individual case to say whether certain behavior is compliant or not. And this is lengthy, and we know the consequences of this. And the DMA is kind of departure from this. And the DMA has now already entered into force. After the DMA has entered into force, the big undertakings that could be potential addressees of the DMA, actually they themselves have to look whether they pass certain thresholds with regard to, for instance, users they have. And then they have to check, could I be subject to the DMA? Then they have to notify this to the Commission, and then the Commission officially designates a certain undertaking as a gatekeeper. And then these gatekeepers are subject to the obligations that the DMA stipulates in Article 5 to 7. And a few undertakings have already been designated. So that's the usual suspects in digital competition law: Alphabet, Amazon, Apple, ByteDance, Meta, Microsoft, and Booking. It's important to say that these undertakings are not, they are designated as gatekeepers, but not the undertakings globally as such are subject to all obligations of the DMA, but certain services of these undertakings. But I won't go into this detail because it's not so important for my topic. And then if the gatekeepers are designated, they have 6 months to comply with the obligations of the DMA. And again, as I said, it's per se rules. It's not the more economic approach. So they actually should be able to, that's the regulatory concept, they should be able to know what they have to do. And then the gatekeepers have to hand in compliance reports. So that's the concept. The gatekeepers design their measures to comply with the DMA, and they report to the Commission, I have done this, I have done that, and the Commission can determine whether this is okay. And of course, every researcher can do this, and actually this is done at the moment. And there are already some investigations of non-compliance underway. And already during, as I said, the DMA is a deliberate departure from standard abuse of dominant proceedings, enforcement in competition law. It stresses per se rules, and it wants to have less assessment of individual circumstances to make enforcement quicker and therefore more effective. And of course, there's a flip side of this approach. We can't have sound economic analysis of each individual case, and we can have at least less assessment of individual circumstances. This is partly a trade-off because we might now accept more over-enforcement, whereas we maybe previously accepted more under-enforcement. And this is a deliberate shift to have, in case of doubt, more over-enforcement because it's considered so dangerous that markets might tip. Nevertheless, of course, we might need a certain degree of flexibility, and we cannot do without any assessment of the individual case. And this is actually the topic of my presentation. To what degree are there efficiency considerations, nevertheless, despite of this regulatory shift, in play in case of investigations of non-compliance or investigations of the Commission? And of course, I have to say as a disclaimer that so far this is a purely theoretical or doctrinal analysis because the first cases just start. So I can't rely on court judgments on the DMA already. This still has to come. But nevertheless, we have to analyze the DMA first to know how the parties should behave. And the first way to approach this issue or this question is to look at what the legislator intended to do with the DMA. So to look at the voices during the legislative process. How was the DMA discussed? Sorry. And the Commission, when it proposed the DMA, it actually explicitly rejected an efficiency defense. So the legislative history of the DMA is actually in 2 steps. The European Commission had first proposed a later abandoned new competition tool, which is something that now might come later on because Germany actually pushes for this to be introduced. And Germany has actually introduced a kind of new competition tool procedure in German competition law right now. Maybe we can talk about this in the discussion later. And actually also Thomas, who is here in the audience, has published about it, as far as I remember. And it's quite interesting, but it's more about the possibility to structurally intervene if we have any problem in the market. So in the DMA, it's more about the C rules, and the Commission didn't want an efficiency offense in that regard. It argued that in the past, experience has been that efficiency arguments by the big companies including the platform companies, have been usually one-sided. So they have very much been from the perspective and for the utility of the big companies. And it's inconsistent with the functioning of digital markets, because usually it's a widely shared finding that competition in the digital economy is not functioning sufficiently to the detriment of users and society. That's what the Commission said. And apart from that, so far, no company in the European courts, no company has been successful so far in arguing on efficiency. So we haven't had a successful efficiency of defense, even in competition law so far. So the Commission said we don't have to make lots of fuss about that and lots of elaborate proceedings about that if it has no use in the end. The Council of the European Union, another organ that's active in the legislative process, there actually the issue was controversial. So there were some member states who proposed the possibility of gatekeepers to make use of efficiency and objective justifications for their conduct to better take into account the impact of gatekeepers' behavior. Whereas other member states were of the opinion that such a possibility would weaken the DMA and its enforcement and make it more cumbersome and lengthy. And actually the latter opinion prevailed. And finally, the European Parliament, here again, the issue was in dispute. So there were several amendments to the DMA proposed with conflicting intentions. So one, for instance, was it proposed a former Article 7, which now basically corresponds to Article 8 of the DMA. The gatekeeper shall be responsible for and be able to demonstrate full compliance. This actually is the law now. So, but there have also been other proposals, for instance, saying that the burden of proof regarding the efficiency lies on the gatekeeper. If this would have been the law, or would have been put into the law, it would have been could have been inferred that you can argue based on efficiencies, but it's the gatekeeper has to prove them. This is now the concept actually of Article 19A of the German Act Against Restraints of Competition, but it's not the approach of the DMA. And there has also been, this is quite interesting, there has also been a proposal to explicitly exclude efficiency arguments from the regulatory dialogue. So it was suggested, I've put it here on the slides, to add in Article 8 a provision saying that the regulatory dialogue should by no means constitute grounds to assume that the gatekeeper may invoke an efficiency defense. And also this amendment was not accepted. So we don't have a completely clear-cut picture from the legislative process. So we should look into indications in the DMA itself. And there we first have a quite clear picture. We can start with the recitals. The recitals, for those of you who are not so much familiar with European law, it's a kind of explanatory part of each regulation where the legislator puts its intention with the law and where he explains what he intends to bring about with certain provisions of a regulation. And the European Court of Justice often uses these recitals to interpret the regulation. It's not mandatory, it's not binding, but it's important. It's an important tool to interpret a certain regulation. And here we have at least a recital saying efficiencies are not relevant for the designation as a gatekeeper. As I said before, the designation has to be distinguished from compliance with the obligations. Yeah, the designation is just the stage of the proceeding activating all the obligations, and here efficiencies are not relevant. So it's a first indication, but it's not. We cannot directly infer something from this for the obligations. Then we have recitals 10 to 11, which basically describe the DMA as something distinct from the national competition rules that, as the recital says, which provide for the possibility of undertakings to make efficiency and objective justification arguments for the behavior in question. The DMA, on the flip side, the recital says, aims to ensure that markets where gatekeepers are present are and remain contestable and fair, independently from the actual potential or presumed effects of the conduct of a given gatekeeper covered by this regulation on competition on a given market. And furthermore, recital 5 somehow distances the DMA from traditional competition law enforcement, which requires an extensive investigation of very complex facts on a case-by-case basis. So we can conclude that the DMA is construed in such a way that individual circumstances, including efficiencies, are not to be considered when assessing the behavior in question. The DMA even distances itself from such legislation. And it points out the problems that this legislation has brought about. On the other hand, we can also say that the DMA is not completely blind to the consequences that the regulation is intended to bring about. There we can look into Article 1 of the DMA. I don't have it on the slide, which is Article 1 of all regulations is usually the provision of regulation which says which goals a certain regulation wants to achieve. And in Article 1 of the DMA, we can read, the purpose of this regulation is to contribute to the proper functioning of the internal market by laying down harmonized rules, ensuring for all businesses, contestable and fair markets in the digital sector across the European Union where gatekeepers are present to the benefit of business users and end users. So the DMA somehow puts as a yardstick of what he wants to achieve and of the obligations that he stipulates the benefit of business users and end users. If you read this in isolation, you could actually think that if the DMA would be a kind of effects-based regulation. Of course, this is not true in light of the recitals, but the DMA is at least not blind to the consequences that it brings about. And this will be important for later aspects of my presentation. Coming back to these recitals, that certain obligations are irrelevant of the presumed effects, this is something that we can see quite clearly in certain provisions of the DMA that actually can be labeled a kind of efficiency offense. I've said efficiency defense so far, that the undertakings put forward efficiencies to fend off certain prohibitions or obligations, but the legislator can actually deliberately say, I don't want the gatekeeper to be able to profit from certain kinds of efficiencies, because the assumption is that the gatekeeper in certain scenarios can generate superior economic benefits compared to its competitors, which would further solidify its position and which the DMA therefore prohibits in certain scenarios. And we have some kind of efficiency offenses in the DMA, and I've just put two examples here. The first one is from Article 5.2, which is about a combination of data from different gatekeeper services or from different services, not necessarily of a gatekeeper. And for instance, it says there that the gatekeeper shall not combine personal data from the relevant core platform service. This is actually the big dominant service that the DMA primarily targets. So the shall not combine personal data from the relevant core platform service with personal data from any further core platform services or from any other services provided by the gatekeeper, or with personal data from third-party services. This is actually kind of Lex Facebook, if I put it bluntly. So Facebook has done this, collecting data with Facebook social plugins from many different services and from Facebook itself, combining them all together and enabling Facebook to offer a better targeted advertisement. But it can also bring about other efficiencies. For instance, the combination of data can be used to develop new products, or to improve products in other markets, or to identify potential for innovation in other markets. So this pooling of data can bring about efficiencies, but nevertheless, the European legislator says, I don't want this outrightly. Another example is Article 6.2 of the DMA. So the gatekeeper, which is a kind of Lex Amazon, the gatekeeper shall not use in competition with business users any data that is not publicly available, that is generated or provided by those business users in the context of their use of the relevant core platform services, or of the services provided together with or in support of the relevant core platform services, including data generated or provided by the customers of those business users. So again, these information could be, or these data could be used to analyze the market, could give the possibility to test new products, or to identify possibilities for good business, which actually Amazon did, but that European legislator doesn't want the gatekeepers to do this. Regardless of how much efficiencies could be brought about by this. On the other hand, the DMA itself already leaves room for gatekeepers to argue that intervention by the European Commission is unjustified based on their individual circumstances. There we have again to look at the applications itself, and sometimes we have the possibility of the gatekeeper expressly in the DMA to argue here the obligation should not be enforced in a certain way, or I should be able to do something that contradicts full bringing in practice of a certain obligation. These are these provisions for justification in particular circumstances. I have listed a few here, and we don't have to look at all of them, but just to give you an example, this is Article 6.4, which is an obligation. Usually it's about vertical interoperability. Here it's about the gatekeeper shall allow and technically enable the installation and effective use of third-party software applications or software application stores using or interoperating with its operating system, and allow those software applications or software application stores to be accessed by means other than the relevant core platform service of the gatekeeper. So it's kind of vertical interoperability obligation. And here it says, the gatekeeper shall not be prevented from taking, to the extent that they are strictly necessary and proportionate, measures to ensure that third-party software applications or software application stores do not endanger the integrity of the hardware or operating system provided by the gatekeeper, provided that such measures are duly justified by the gatekeeper. So we have here a certain scenario where the European legislator has been aware of the fact that just a blunt obligation to allow vertical interoperability could have disadvantages in an individual case, and the gatekeeper is explicitly allowed to put forward that therefore it must have some measures in place that detract from full vertical interoperability. So this is what the DMA says itself. And from that, we can actually say that as in regular cases, other kinds of efficiencies should not be looked at. However, the statements above do not necessarily mean that the Commission could or should completely disregard any efficiency considerations in the enforcement of the DMA if efficiencies, and this I think is the decisive aspect, work to the benefit of business users and end users, which the DMA actually wants to protect. And in the following, I will examine possible points of entry for efficiency considerations in proceedings under the DMA. And sometimes I think you can argue for a point of entry, and sometimes I don't think you can do this. And again, it's kind of we again have this contradiction between flexibility on the one hand and a per se approach regulation on the other. So the general concept, as I said, is to have short procedures, per se rules, form-based approach, and this is actually the summary what I've said so far now, which is no effects analysis, especially for Article 5, which says these are provisions that you have to comply with in any aspect, and you don't have to adapt them to individual cases. So we basically are prepared to accept more over-enforcement, and we don't have a general, and we have sometimes even efficiency offenses. And nevertheless, we have certain opportunities for efficiencies to come into play, and I will go into these in more detail in the following. So the first one is what I already have mentioned briefly, this Article 8 saying that gatekeepers have to ensure compliance themselves. So it's actually the gatekeepers designing the compliance measures. And implementing acts by the Commission that shall be effective, but that also have to be proportionate, and compliance reports. So this is the basic approach of the DMA. The gatekeeper can design implementing acts and thus take their business models into account. So it's not the commission telling the gatekeeper, you have to do this and you have to do that in the standard case. The commission can do this in certain cases, but compliance in the regular case of the DMA is we have these obligations. These obligations are actually strict per se rules, but the gatekeepers have the strict per se rules and they can decide how to implement them. And in an ecosystem, in a platform business, you usually have several ways to bring about certain effects. To how can you implement vertical interoperability, which protocols do you use, etc. So you will have a certain margin of discretion how to ensure compliance. And the DMA gives this margin of appreciation to the gatekeeper for two reasons. The first is it just makes it easier, of course, because if the commission would have to specify in every detail what the gatekeeper would need to do, that would be very complicated. The commission would have to delve into lots of technical details. And so it makes things easier for the commission, but it also makes things easier for the gatekeepers because they themselves can look at their business models and they can try to implement the DMA in the least intrusive way possible that respects the obligations of the DMA on the other hand, but also efficiencies and the business model of the gatekeeper on the other hand. On the other hand, this also has disadvantages because the gatekeepers could also try to just follow the wording, but not the spirit of the DMA. And then we have the next problem with this circumvention. That you could just follow the DMA on paper, but try to somehow undermine the effects that the DMA wants to bring about. And the commission or the DMA tries to tackle with this with an extensive provision on anti-circumvention. I won't go into details in my talk. We can do it in the discussion, but this is a basic concept. And the basic concept, this is my point here, allows the gatekeeper for some flexibility in complying with the DMA. And this is at least a certain possibility to take into account efficiency. And now I want to go into more detail into the enforcement proceedings and the possible enforcement proceedings or the DMA procedure goes on like this. So first, the commission has to make a decision whether to intervene in a certain case, which is discretionary. The commission doesn't have to intervene. And first here we have to ask, is the commission allowed to take efficiencies into account when deciding whether to intervene in a certain case? Although the DMA itself says efficiencies are not actually relevant for complying with a certain obligation. But the commission might be able to consider it when deciding to intervene or to not intervene. Then we have we are at the stage of finding of non-compliance. Again, we could ask, is there some kind of efficiency in play here? Objective justification would be the buzzword for this. Then it's about designing of remedies. Here I'm not in the regular case. I'm in the somehow irregular case where the gatekeeper has not complied properly, and now the commission says you have to do something, and the remedies are designed by the commission. And the commission can also set fines. And again, we can ask, are efficiencies a relevant criterion for determining the fine in DMA proceedings? So could we lower the fine if a certain infringement of the behavior has nevertheless brought some efficiencies about, although the DMA distances itself from efficiencies? So first stage is, and then I have some aspects that I've labeled miscellaneous. Miscellaneous is not a very good word here, but it means aspects of the regulatory proceedings that I cannot exactly put into this time scale. So for instance, the market investigation, it comes usually after the very end. In case of systematic non-compliance, the regulatory dialogue can actually occur in several stages of the proceedings. So the companies can initiate themselves, or the commission can initiate it without any deviation from the DMA or any non-compliance problem, but it can also be done in parallel with non-compliance proceedings. So yeah, it can occur in various stages. And structural efficiencies is another aspect that I will discuss in the end. So we start first with the question whether the commission can take efficiencies into account when it comes to the decision whether to open proceedings. And there I think we have to distinguish two scenarios. The first scenario is, can the Commission decide, oh, this behavior, I think this behavior brings about lots of efficiencies, and therefore I think I should go after this behavior, although this behavior is in contravention of a certain obligation of the DMA. And my co-author and I, Marcel Zuber, we think that this is not possible, because if the Commission would do this, it would actually contradict the goal of timely intervention. It would actually contradict the obligation in Article 5 and to 7 DMA that were developed in anticipation of possible justifications. So the DMA already contains provisions and possibilities for consideration of efficiencies, as shown already later. And these are, if the Commission would unilaterally say, I think that a certain behavior, though prohibited in the DMA, does not deserve enforcement, this would be, this would be against the DMA, and therefore we think that this cannot be done. The more interesting question is about enforcement priorities. So the European Commission has limited resources. I think it's about, there's actually a number of staff that has been allocated to the DMA, and there's been lots of critique that this would be not sufficient. So you can discuss, it could be the case that the Commission has certain possible cases of non-compliance, and the Commission has to decide to go after one, but it cannot go after the other because its resources are just not sufficient. And then again, it can be asked, how shall the Commission make this prioritization decision? And there we can look at competition law proceedings, or at the experience in competition law proceedings, and the effects that are brought about can actually be taken into account. So here the European Commission must take the effects of a conduct on contestability and fairness to the benefit of business users and end users into account. And this would necessarily include circumstances that mitigate the harmfulness of the behavior in question, including efficiencies, to the extent that they benefit business users or end users and promote fairness in the market. So this is similar to the practice regarding Article 101 and 102 TFEU about rejection of complaints. There we have a Commission notice on best practices. And there the Commission says, if there's a lack of European interest, then this actually can motivate the Commission not to pursue a certain case. And there are certain grounds for assuming this. So it might be a limited likelihood of establishing the proof of an alleged infringement, but it might also be in light of its expected limited impact on the functioning of the internal market, and it's about how serious the alleged inferences with competition are and how persistent the consequences are. So also there, the Commission looks at effects. And this has also been confirmed by the European Court of Justice. And this jurisprudence is not directly applicable to the DMA because it has been made there in the context of a complaints procedure that the DMA does not have in this exact way. But nevertheless, the DMA has to apply it with the goals in mind, and the goals shall work to the benefit of business users and end users, and therefore efficiency considerations can come into play here. So we think, yes, the Commission can consider efficiencies when prioritizing its DMA enforcement. However, there are also three limitations that I should stress. First of all, the first question is, how far can the Commission go in that regard? So if you assume that the Commission has really lots of cases or prioritizes very strongly and says, okay, I don't allocate any enforcers to the DMA, I allocate all its resources to 101 and 102 TFEU, and I pursue only very limited cases, then it would actually be able to bring about the kind of consumer welfare-led enforcement of the DMA. And this would then contradict the intention of the legislator. So that would actually go too far, but to a certain dose, I think this should be possible. The second important limitation is if we are in the stage of whether to open proceedings or not, it's a very preliminary stage of proceedings. So the knowledge of the commission should usually be very limited. And this, of course, also limits the analysis of efficiency that you can reasonably do. So it will only be a very rough and ready efficiency analysis. So maybe it will only be able to look at the typical degree of harm rather than to look at the concrete degree of harm in an individual case. Last point, a gatekeeper which has a very strong market position is not very likely to pass on efficiencies to business users and end users. So you could be skeptical that efficiencies can be a good argument to not go after a certain infringement, but at least we think that from a final point of view, the commission is allowed to do that. It's not obliged to do so, but we think it is allowed to do so to a certain extent. Second point, and we go now on in our proceedings, is the commission allowed to find non-compliance based on an argument of efficiencies. By the way, just to explain my slides here, you see now where's discretion to intervene. In light gray, it's non-intervention. So light gray means we don't think efficiencies can come into play here. We have underlined enforcement priorities because we think efficiencies come into play here. That is how I summarize my results in the following, in the slide. So we will look at this slide again and again, and we will go through we'll get down the line of the proceedings, and I will have my results summarized in that way. So finding of non-compliance. This again goes to the beginnings of the DMA, because parts of literature have argued if we have a per se prohibition which prohibits I have to start anew. This has been a frequently voiced criticism during the legislative process in particular, was that the obligations laid out in Article 5 to 7 are not empirically justified, at least partly, and they do not necessarily target anti-competitive behavior. Thus, the argument goes the DMA harms innovation, and therefore it was argued that the DMA would violate the principle of proportionality. And so one could think, okay, maybe is it really possible for the DMA to prohibit behavior that's maybe just not harmful? And how could we actually repair this if the DMA would not be allowed to do this? So we can momentarily, I don't share this view basically, but just for the sake of the argument, we can accept it and assume for the moment that this view here that's been put forward in literature is correct. Then it still remains unclear how we should take it into account when applying the DMA. There's a certain doctrinal technique that we could use in that regard. It's called theological reduction. And the theological reduction is actually applied in cases where the wording of a rule is too broad and covers circumstances that should not be included with regard to primary law. So if we think the DMA is just too broad, it prohibits behavior that is not harmful, and this contradicts primary law, we could think about, can we narrow the scope of the DMA by interpretation to put it in conformity with primary law that is superior to the DMA? This is the question that we can ask. However, we think that this does not work because the European Commission and the ECJ are not authorized to amend the content of the law in that way. So a theological reduction is inadmissible where it contradicts the wording and the objective of the law. We could do a theological reduction if the legislator has had a certain intent, but has formulated the rule too broadly without wanting to do this, just because he has made a mistake when putting the rule in words. However, if the legislator wanted to have the rule that broad, we cannot narrow it down by interpretation. If the legislator wanted it to have that broad, and you assume this is unconstitutional because it contravenes primary law, then what you have to do is actually you would have to bring forward an action of annulment against this rule or against the DMA. And you can't narrow it down by interpretation. You just have to fight the validity of the law. So yeah, we cannot say that. So it's not possible to come to a finding of non-compliance by objective justification, even if we assume that a rule of the DMA is too broad and therefore contradicts primary law. We could remedy this only by declaring the DMA invalid. We cannot do this by narrowing it down by interpretation. So we don't think that efficiencies can come into play here. No possibility for objective justification. Then we turn to the next stage of our proceedings, namely the designation of remedies or a non-compliance decision. So, and there different stages come into play. I have listed them here. I will go, this is also the regulatory dialogue, because as I've explained briefly further, regulatory dialogue can come into play at different stages of the procedure, and it's likely to be at play when non-compliance could potentially occur. So we have three aspects I want to look at: regulatory dialogue, non-compliance decisions, and remedies in case of systematic non-compliance. So I'm starting with the regulatory dialogue that is in Article 8 DMA. Pursuant to Article 8, Section 2 DMA, the European Commission may adopt and implement an act specifying the measures that the gatekeeper concerned is to implement to effectively comply with the obligations laid down in Articles 6 and 7 DMA. And in the administrative proceedings that precede this decision, the gatekeepers can argue on the basis of individual circumstances, and we believe that the Commission must take this arguments based on individual circumstances into account because of the principle of proportionality. So the Commission, of course, is allowed to fully make the gatekeeper compliant, but it is not allowed to ask the gatekeeper for measures that are not necessary, that are not strictly necessary to achieve this result. So the gatekeeper can make an argument based on his individual circumstances, and partly efficiencies can also come into play here, because efficiencies mustn't be compromised more than necessary to comply with the DMA. So we have a certain room actually for efficiencies to come into play here, because the Commission must respect the principle of proportionality. At the same time, we have again some limitations because it's only about specification. It's only about specification of a certain obligation that the gatekeeper has to respect. It is not possible to declare a certain obligation inapplicable, and it's not possible to limit the scope of a certain obligation. Nevertheless, as I said, in an individual case, the circumstances of the case at hand can come into play insofar as we can have the least intrusive way of respecting a certain obligation. So this is again a reminder on when the regulatory dialogue can start. It can start standalone, so it just can start because maybe the gatekeeper asks for it, or because the Commission thinks it's suitable to specify what the gatekeeper has to do in a certain scenario. But it can also be accompanying to a non-compliance procedure in case of Article 6 and 7 DMA. So and these non-compliance proceedings have different stages listed here, and I will go into detail now. So we look at non-compliance decisions now. Non-compliance decisions are have a provision in Article 29 of the DMA, and they again consist of certain stages. The first stage that I want to look at is Article 29, Section 3 or subparagraph 3, saying that before adopting a non-compliance decision, the Commission shall communicate its preliminary findings to the gatekeeper concerned. In those preliminary findings, the Commission shall explain the measures it is considering taking, or that it considers that the gatekeeper should take, or that it considers the gatekeeper should take in order to effectively address the preliminary findings. So explain either the measures that the Commission is considering taking, or that the Commission considers that the gatekeeper should take. So this is what the Commission is expected to do in this stage. So it has no obligation to design remedies, but it has the possibility to provide the gatekeeper concerned with certain guidance. We don't know already how extensively the Commission will make use of this possibility. If we look at competition law proceedings, the Commission usually does not design remedies itself, but leaves it to the undertaking. In this way, the Commission can sidestep information asymmetries in basically. And possibly this is to be expected for the DMA too, but nevertheless, it has been suggested in the literature that it may be expedient to provide guidance to the gatekeeper at this point of the procedure. It's reasonable to assume that after a non-compliance decision, we will have a certain kind of regulatory dialogue or in conjunction with such non-compliance decision. And this would actually be in line with practice that we have under Regulation 1762, though the predecessor of the now competition procedure regulation, because there was an Article 3 of this Regulation 1762 that did not authorize the Commission to order remedies. However, the European Commission could, before taking a decision, address the undertaking concerned with recommendations for the termination of the infringement. And this is actually quite similar to what Article 29, subsection 3 does now. And the gatekeeper will have strong incentives to get these recommendations because he wants to avoid a fine, basically. So, and here again, the rationale applies that I've presented before. If the European Commission uses the opportunity to provide guidance to the gatekeeper, it must, of course, take fundamental rights into account. Therefore, it has to take the principle of proportionality into account, and therefore it must not interfere with efficiencies more than necessary. So it must take efficiency considerations into account insofar as this can be done while respecting the obligations of the DMA. Again, however, this is limited by several points. First of all, as I've explained at the beginning, sometimes the DMA contains efficiency offenses. So the legislator deliberately does not want to realize the gatekeeper certain efficiencies. Of course, these efficiencies cannot be respected here. Only efficiencies can be respected that are not forbidden by the DMA. So insofar as we don't have an efficiency offense in the DMA. Second, we must bear in mind what the regulatory concept of the DMA is. So the gatekeepers must ensure that they comply. And we would suppose, but as I said, we don't have practice yet, that the Commission will rather only provide rather general guidelines. And the more general the guidelines for enforcement are, the less is the opportunity or necessity to go into efficiencies for a case at hand that could be respected despite of full compliance. And third aspect, which is very important, when it comes to defining what exactly the gatekeeper has to do to comply effectively with certain obligation, we will usually have so-called complex economic assessments. This is a technical term in European competition procedure because the European Court of Justice argues that if we have complex economic assessments that the competition authority at the European Commission has to do, then the European Court of Justice applies a weaker standard of review. And therefore, it will be difficult or more difficult for the gatekeeper to attack a certain assessment of the European Commission if it involves technical complex economic aspects, because the Court of Justice gives the Commission a wide margin of appreciation. And finally, we are here, it's about recommendations. So it's not about the Commission issuing a binding decision that the gatekeeper has to do certain things, but it's only that the Commission says what the gatekeeper should do in view of the Commission. It's not completely binding. And again, we believe that, we would argue that the Commission may therefore be content with a lesser degree of scrutiny in that case, especially if there's a cooperative exchange. So if the gatekeeper somehow agrees with a certain degree recommendation by the Commission. So the next stage are then, so Article 29, we are in subparagraph 3. This is before adopting a non-compliance decision. The Commission shall communicate preliminary findings, which is similar to competition law proceedings, and somehow, give the gatekeeper recommendations what to do. if we have passed this stage, then we actually come to a non-compliance decision, Article 29, subsection 1. So it's a bit in a strange order, but this is how Article 29 is designed. So then we have this non-compliance decision, and the interesting thing is, in this Article 29, subsection 3, before adopting a non-compliance decision, the Commission shall explain the measures that the gatekeeper should take. But if the Commission adopts a non-compliance decision, actually it has not the possible, it cannot specify a possible remedy. So this is the strange thing. So in the preliminary stage, the Commission can recommend the gatekeeper a remedy, but it cannot impose the remedy when it takes that decision, to our understanding. It can use Article 8.3 for this, so the regulatory dialogue procedure, but not Article 29. There's no specification of remedies, therefore no efficiency arguments can come into play here. What might be possible is that the European Commission, of course, has to take the principle of proportionality into account when it interprets the DMA. So I said the DMA is about per se rules, and of course this is the intention to have a very precise rule that tells you exactly what you have to do. Nevertheless, in a certain scenario, it might be that there's nevertheless some room for interpretation, that you can interpret a certain obligation in that way or in that way, and again then we can argue again that efficiencies can come into play because the Commission might be obliged to take an interpretation that is less intrusive into the rights of the gatekeeper. And what the Commission can also do, Article 29, subsection 5, it can issue a cease and desist order in the non-compliance decision. So the Commission shall order the gatekeeper to cease and desist with the non-compliance within an appropriate deadline and to provide explanations on how it plans to comply with that decision. So the gatekeeper must provide an explanation how he wants to comply with cease and desist. The Commission arguably cannot exactly impose this. So again, we have the distinction to competition proceedings, and we see again efficiencies can come into play to a limited extent, but nevertheless, as it is put on the slide, of course, I do not want to dispute in any way that the guiding principles for interpretation are fairness and contestability, but nevertheless, it's about fairness towards business users and end users. So efficiencies that are positive for business users and end users should be able to come into play here because they do not distract from the goals of the DMA. Important to keep in mind, I've mentioned it already, we can have a regulatory dialogue in parallel, and there the Commission can impose measures. It's called regulatory dialogue, which is partly an historical reason why it is why Article 8.2 is called this, but actually what Article 8.2 is about is that the Commission may adopt and implement an act specifying the measures that the gatekeeper concerned is to implement in order to effectively comply with the obligations laid down in Article 6 and 7. So there's supposed to be some dialogue, but in the end, the Commission can unilaterally impose acts on the gatekeeper. So then we have a third enforcement scenario. This is remedies in case of systematic non-compliance. So this is here in the market investigation scenario, Article 18. So this is again a peculiarity of the DMA because the DMA says, you have 3 strikes. I have to look at you have 3 strikes. If you have 3 non-compliance decisions against you as a gatekeeper, then the European Commission can actually really wield a hard stick and impose more strict measures in you. This is systematic non-compliance, and then the Commission can impose very strict remedies, in particular also structural remedies. So, and this is actually the first question that we can have here, because Article 18 if we have systematic non-compliance, it allows the Commission to impose behavioral or structural remedies. And the interesting thing is, Article 18 does not provide us with an order. So it does not say you have to impose behavioral remedies first and then only structural remedies. It's just, if you look at the provision, it's actually on equal footing. Nevertheless, we should say, or the DMA in this regard cannot depart from primary law. And as a general matter, we still think that structural remedies are somewhat subsidiary. So the DMA, to a lesser extent, wants to be this the case, because again, the principle of proportionality has to be respected, and there's no legal stipulation needed for this in the DMA. And if structure, and here two aspects have to be considered. First, structural remedies might intrude more deeply into the rights of the gatekeeper. But secondly, structural remedies can also harm efficiency. So economies of scale and scope and the ability to innovate. We know that, and also on Ascola in Würzburg, there's been a paper presented. There's no linear correlation between size and innovation. So we don't argue that there is a strict coincidence of a big gatekeeper and much innovation. This is certainly not the case. And we also are aware that is a dispute, that there are certain kinds of innovation. You might have predatory or exploitative innovation, and you might have innovation for new products. But nevertheless, these are aspects that the Commission at least has to consider. And therefore, arguably, nevertheless, there's that the less intrusive remedies have to be taken first as a basic principle. However, of course, we are in a scenario where we have multiple violations of the law by a gatekeeper, and this also militates for strict enforcement at the same time. And then it comes to the designation of remedies. So again, the principle of proportionality comes into play. So the interests of the gatekeeper are to be taken into account, especially also their ability to innovate. But we know antitrust practice, the Commission usually is reluctant in designing remedies itself. The concept of the DMA is otherwise. So it remains to be seen to what extent the Commission will make use of this tool to impose remedies on the gatekeeper in case of systematic non-compliance. It can do so, but probably it will not do so on a very broad scale, because this will tie up many resources, and maybe the Commission has easier possibilities to go after a gatekeeper. Yeah, and then we are in the final stage of proceedings, namely it comes to the setting of a fine. And yeah, so we would say in the regulatory dialogue, efficiencies are probably most important. In market investigation cases, efficiencies can, to a certain degree, come into play, but we haven't underlined it, because in a market investigation for systematic non-compliance, we also know that severe measures are necessary. So it can come into play, but only to a limited extent. And then the setting of a fine. And here, actually, we can have a very similar line of reasoning when as I had when about the discretion whether to intervene in a certain case. We can again ask two questions. The Commission first has discretion whether to set a fine at all, and second, it has discretion what the amount of the fine should be. And with regard to these two aspects, we can ask whether efficiencies can come into play. And again, we would argue that when it comes to whether to inflict a fine or not to inflict a fine, the Commission cannot say, I don't inflict a fine on this behavior at all, because I think, well, it contradicts the DMA, but there's so much efficiencies, I don't want to fine it. If the Commission would do this, we think that this would actually again depart from the intention of the legislator of the DMA. We can in both of these aspects. So we feel it is not possible for the European Commission to refrain from imposing a fine due to efficiency. The second, more interesting question is: can the Commission take efficiencies into account when it comes to the setting of the amount of the fine? And there we can look into the DMA, and the DMA says that the gravity of the infringement is something that the European Commission has to take into account. So the gravity, the duration, the recurrence are aspects that the Commission has to take into account. For us, for our topic here, the gravity of the infringement is the most interesting aspect. So we can again look at to competition law practice. And there also in Regulation 2003, the Commission has to take the gravity of the infringement into account. And this includes all the legal and factual circumstances. And in competition law proceedings, the gravity of the infringement is to determine inter alia in light of the effects on the conduct of the market. And similarly, in DMA procedures, the impact of the behavior on fairness and contestability has to be taken into account. To the benefit of business users and end users. And unfairness in the DMA, according to recital 33, relates to the imbalance between the rights and obligations of business users, where the gatekeeper obtains a disproportionate advantage. And in particular, business users shall benefit from their success. So, and this is recital 33. Due to their gateway position and superior bargaining power, it is possible that gatekeepers engage in behavior that does not allow others to capture fully the benefits of their own contributions, and unilaterally set unbalanced conditions for the use of their core platform services or services provided together with or in support of their core platform services. So if we have certain efficiencies, and if the gatekeeper passes on these efficiencies, we could argue that fairness is not so much infringed, is not so much detracted from, and this therefore means that the infringement is less severe. And this can also mean that the Commission can take this into account when setting the fine. This is our view. However, again, a limitation. When we look at Regulation 1003, so competition law proceedings, there's no obligation for the Commission to take the gravity of the infringement into account. The Commission can do this. It does not have to do it. That seems to be the line. And yeah, you can actually adapt that or transfer that to DMA procedures. So in line with these considerations, efficiencies can be taken into account when setting the amount of the fine, provided that the efficiencies benefit business users or end users and thus contribute to a fair market outcome. But if we look at competition law proceedings, the Commission is possibly not obliged to assess the impact of the behavior on the market. And it is therefore been also pointed out in the literature, if it doesn't have to assess the impact of the behavior, it also doesn't need to assess efficiencies. And the literature has also pointed out that it's very difficult to determine the gravity of an infringement in that way. And therefore, the Commission might just say, I don't do this. So fines, we have looked at fines now, and now I have just one point left, and these are structural efficiencies. And this is a peculiar aspect I've mentioned here under miscellaneous. And this again brings us to the purpose of the DMA. And I've also drawn to fairness as a purpose of the DMA, but we have also a very important purpose or goal of the DMA, that's contestability. And we have a definition of contestability in recital 32, saying that for the purpose of this regulation, contestability should relate to the ability of undertakings to effectively overcome barriers to entry and expansion and challenge the gatekeeper on the merits of their products and services. The features of core platform services in the digital sector, such as network effects, strong economies of scale, and benefits from data have limited the contestability of those services and the related ecosystem. And here so the DMA aims to protect contestability and fairness. It's generally a form-based approach, but we can ask whether there is a link between contestability and efficiencies. And it appears consistent to take efficiencies into account that have an impact on the structure of the market and can therefore promote contestability. So, and of course, insofar as the gatekeeper's products or services leads to superior efficiencies to the benefit of business users and end users, these might so ought not impede a competition on the merits and might therefore not impinge on contestability. So we want to draw a brief comparative line for how we think one might do this to German merger control. So a very different area of law, and you can directly adapt this to the DMA, but just to give an illustration, there we have a so-called balancing clause in section 36, saying that the Federal Cartel Office can clear a merger that will significantly impede effective competition if the undertakings concerned prove that the concentration will also lead to improvements of the conditions of competition, and that these improvements will outweigh the impediment to competition. Since it was previously contested, but previously it was said that only circumstances could be taken into account that have a structure on the market. But even at this point in time, structural efficiencies were never completely disregarded. And because the goal to protect the structure of the market does not make it necessary to disregard all kinds of efficiencies. Certain efficiencies, can have a positive impact on the structure of the market. And when can this be the case? It has been acknowledged, for instance, in the case of a merger between an electricity company and a gas supplier that leads to effective competition between oil and gas suppliers. So this has been about a merger of grids. I think that it was about rationalization benefits resulting from a merger between an electricity company and a gas supplier, and these could be taken into account under this balancing clause, provided that the merger leads to effective competition between this oil and gas suppliers and thus improves the structure of the market. And we believe that these considerations on the balancing clause are, in certain aspects, transferable to DMA procedures, insofar as the contestability of the market is discussed. So if behavior in question improves the competition and has a positive impact on the structure of the market and can make it possible to competitively challenge products and services offered by the gatekeeper, which is in the broadest sense similar to this balancing clause. In particular, tying and bundling can be pro-competitive in markets where gatekeepers compete with each other. This is a scenario, I think, where this might be interesting. So in the pattern of argumentation of this German Eckart Bueren case, it's relevant in markets where gatekeepers compete, where a gatekeeper competes with another gatekeeper in a market dominated by the latter. So we have one gatekeeper dominating in the market, we have another gatekeeper who is also in this market, and this gatekeeper is able to realize certain efficiencies which make it possible for this gatekeeper to better compete with the other gatekeeper, improving overall the structure of the market. And then we have a follow-up question. If we think that this could be a valid line of reasoning, how can this be practical in the DMA? I've already argued that there's no general objective justification in the DMA. So we cannot use it. We cannot use this line of reasoning to set aside one of the prohibitions in Article 5 to 7 DMA. We don't accept an objective justification. But we think there are two scenarios where this could be relevant. The first is a provision that I've mentioned only briefly so far, the anti-circumvention provision. So I've mentioned that the gatekeepers usually design the remedies or their compliance measures themselves. And there's the risk that the gatekeepers might just do this in a very lenient way because they do not want to fully comply. They want to comply with the wording, but not the goals of the DMA. And therefore, there's a very broad provision of anti-circumvention. It's actually extremely broad. So it says the gatekeeper shall not engage in any behavior, regardless of whether it is contractual, commercial, technical, or of any nature that, while formally, conceptually, or technically distinct to a behavior, prohibited pursuant to Articles 5 and 6, is capable in practice of having an equivalent object or effect. So it's very broad anti-circumvention provision. this is what Parliament has written about this Article 34. So I've just cited. I should clarify this. I've just cited not the law, but what Parliament said about it, and I'm quoting this because it's actually quite difficult to interpret this Article 13.4. Now, what is anti-circumvention? What is not anti-circumvention? Article 34 is very similar. It's actually, yeah, it's I have to check. Yeah, it's very Article 34 is actually almost the same to what I've quoted. Gatekeeper shall not engage in any behavior that undermines effective compliance with the obligations of Articles 5, 6, 7, regardless of whether that behavior is of contractual, commercial, or technical nature, of any other nature, or consists in the use of behavioral techniques or interface design. So this is what the laws finally have been. So it's very similar. And this term undermining that is used here, if it's used in other areas of the law, it usually refers to behavior that is contrary to the objective of the law. And so we have to look at whether the gatekeeper acts in line with the goal of the obligation. And we would argue that if we have this kind of structural efficiencies that actually can improve contestability in a certain scenario, and that therefore lead to more competition in the market, we would say that the behavior cannot be subject to the anti-circumvention clause, even if the behavior in some of its effects looks very much like one of the prohibitions in Article 5 to 7, which is not fulfilled by its wording. So one could think at face value, it's not the prohibitions in Article 5 to 7, but it's very similar to the prohibition in Article 5 to 7, but it has structural efficiencies that actually improve competition on the market. Then we would argue you have to consider these efficiencies when it comes to the question whether you can apply Article 34. And a final point, when it comes to the updating of obligations, so the Commission has the possibility to introduce other obligations in the DMA, so adopt delegated acts to supplement the regulation with regard to the obligations laid down in Articles 5 and 6. And here again, the question is, the Commission has to do a market investigation, and the question is whether or not the behavior in question may, under certain circumstances, promote competition between gatekeepers. And if this is the case, we think that the Commission should refrain from adding this behavior. Or again, this efficiency should be taken into account when it comes to the question whether adding an obligation to the DMA. So I think I've complied with the Japanese procedure and talked as long as is usually expected. And this is my summary. So the light gray parts of the procedure is where we think efficiencies cannot come into play at all. And the underlined parts are where we think efficiencies come into play, at least to a certain extent. And thank you very much for your invitation, for your attention, and I'm happy to look forward to questions and comments.